A large number of municipalities, counties, and even one state have recently sued the oil companies, some coal companies, some gas companies, all essentially parts of the fossil fuel industry, saying two things. One, that you knew when you were marketing these products back in the 1960s and 1970s and into the 1980s, that the effects of climate change would follow upon their use. And second, you didn't tell anybody.
The public nuisance lawsuits in climate change started around 2017 when you started seeing municipalities bring lawsuits against oil companies to hold companies liable under novel theories of public nuisance claims.
A private nuisance is brought by a private plaintiff as for injuries suffered by their property and the property of the entity, a city, a county, for damages suffered by the public entity as to its property.
An example of a public nuisance is when someone uses their property and doesn't directly impact the property of another individual, but instead impacts something which the public has an interest in the whole, such as a stream. So a discharge into a stream, a discharge into the air that therefore dissipates but nonetheless might have an impact on the entire public. This is not a new strategy. Plaintiffs' attorneys and even some governmental entities have tried to find ways to use the tort system to hold individuals liable for things which were difficult to hold them liable for through legislation. Oftentimes, this was done in a seemingly retroactive manner in which individuals were being told that they were being sued for activities that they conducted in the past. Lead paint, asbestos, tobacco, these are all instances in which lawsuits have been predicated on novel theories of tort liability.
The burden of paying for climate damages should rest with the fossil fuel companies to the extent that they knew that their products were going to cause this problem and didn't tell anyone, didn't disclose it, or in many cases affirmatively misled the public about those consequences. Local governments have to incur increased costs of providing services as a result of climate change. And there are two ways for them to pay for that. One is they can increase taxes on their residents. The other one is to go to the corporations that marketed these fuels for decades without telling people that the consequences of using these fuels and say, hey, you should be held responsible for the damages that your products caused when you knew that what they would be and you didn't tell anyone.
Contrary to asking the courts to get involved, the regulatory or statutory approach is one that should be preferred. It should be preferred from a separation of powers standpoint, first and foremost. That is, courts are meant to say what the law is, not what the law should be. And so from a formal separation of powers standpoint, courts are not well equipped and in fact are not constitutionally permitted to develop new law, to create new law, to announce new policy, or even to look at evidence and try to make a decision on what should be the best policy.
The climate nuisance cases are not seeking to usurp the role of Congress or regulatory agencies in deciding what behavior should be going forward. If Congress or the agencies believe that it's appropriate to reduce carbon dioxide and other greenhouse gases in the atmosphere, they should go ahead and do that. In the United States, federal climate change regulations and federal climate legislation do not focus on compensating local governments. They focus on, going forward, how can we reduce the amount of greenhouse gases going into the atmosphere? And that is a completely separate matter from whether or not the fossil fuel corporations should be held liable to the individual governments.
The public nuisance climate litigation is a way to find funding essentially for public projects and public programs which we believe are necessary today to abate some of the problems that climate change will bring. Therefore, it is not so much about finding the right parties that might have been emitters of pollutants, but instead going after those who we think can better pay the bill. This is not something courts are equipped to do. The legislature and the executive, they are able to balance and take into account competing interests both the economic gain that comes from the activities that we're going to regulate, as well as the environmental harm that comes from those same activities.
These lawsuits are an efficient way of allocating market responsibility. Everyone should want people who manufacture products and put them in the stream of commerce to disclose the problems behind them. And that way, everyone benefits. The market has far more information, and it's a far more efficient system.
The question becomes whether or not the courts are the appropriate venue for determining which activities should be lawful and which activities should not be lawful. That's not what courts are for. When we have a widespread harm with widespread contributors, it calls for a societal solution through the legislative or regulatory branches, rather than through the courts trying to pin the cost on just a few potential contributors.